Let us discuss the next question. This question is from 2015. The provisions in the 5th schedule and the 6th schedule in the constitution are made in order to, so they are asking the intent behind making the 5th schedule and the 6th schedule. Now here you need to recall what is mentioned in 5th schedule. The 5th schedule declares certain areas as scheduled areas and tries to protect the tribes which are there. And 6th schedule declares 4 states and tries to protect the scheduled tribes in those particular areas. Statement 1 says to protect the interest of scheduled tribes. Statement 2 says determine the boundaries between states. C says determine the powers, authority and responsibility of panchayats. D says protect the interest of all the border states. So it is clearly A because it is discussing about the interests of the scheduled tribes. It doesn't talk about the boundary divisions between the states, and also it doesn't talk about the powers, authority and responsibilities of the panchayats, because the powers, responsibilities and authorities of the panchayat, that is dealt in the schedule number 11. And D says protect the interest of all the bordering state. That is also incorrect. So the best answer is A. Now let us look at the in-depth explanation. The schedule 5 deals with administration and also the control of certain areas which are to be declared as scheduled areas. And who will declare them as scheduled areas? It is the president who, through a notification, will declare particular area as scheduled area after consulting the governor of the respective state. And they are done in order to protect the scheduled tribes in those states. Schedule 5 doesn't deal with the states of Assam, Meghalaya, Tripura and Mizoram, because the specific provisions with respect to AMTM, that is Assam, Meghalaya, Tripura and Mizoram, are dealt in the separate schedule, that is the 6th schedule. Hence the answer is A, where it clearly says to protect the interests of the scheduled tribes. So schedule 5 and schedule 6 tries to protect the interests of the scheduled tribe. Let us discuss the next question. This question is from 2019. Under which schedule of the Constitution of India can the transfer of tribal land to private parties for mining be declared null and void? The question is asking about the particular provision under the schedules of the Constitution. Option A, 3rd schedule. Option B, 5th schedule. Option C, 9th. Option D, 12th. Now how can you solve this question in the exam? For this you need to recall what are mentioned in different schedules. If you recall what is mentioned in the schedule number 3, it is about the oath and affirmations of different category of persons. When it comes to 5th schedule, it is about the maintenance of the areas which are declared as scheduled areas other than 4 states. When it comes to 6th schedule, it is about the maintenance of certain scheduled tribes in the states of AM, TM. When it comes to 9th schedule tries to protect certain acts from judicial review which are added to the 9th schedule. When it comes to 12th schedule, the 11th schedule discusses about the provisions of panchayat, and the 12th schedule discusses about the provisions of the municipalities. What are all the applicable provisions for the municipalities? So now what is the relevant schedule for this particular question? It will be schedule number 5th. So answer will be B, because a transfer of a particular tribal land through a private party is restricted under 5th schedule, where protection is given to certain tribes which are there in the scheduled areas which are declared in the 5th schedule. Now let us look at the in-depth explanation. The schedule number 5 in the Constitution has provisions related to the administration and the control of scheduled areas and scheduled tribes, the exception being the states of AMTM, that is Assam, Meghalaya, Tripura and Mizoram. The provisions with respect to these states are mentioned in the 6th schedule. Who designates some area as a scheduled area? It is the president who declares the area as a scheduled area, and after the consultation of the respective governor of that particular state. The governor is mandated to submit a report to the president annually on the administration of the scheduled areas, and also whenever the president wants him to submit a report. The governor has power to make regulations for the peace and good governance of those scheduled areas after consulting with the Tribal Advisory Council. The advice tendered by the Tribal Advisory Council is advisory in nature. As the name itself suggests, they are not binding in nature. And what are all the regulations that are made here for protection? The regulations will prohibit or restrict the transfer of land. The regulations can restrict the transfer of the tribal land to non-tribal people. The regulations can restrict and regulate the allotment of the land. The regulations can also put some conditions on the money lending business in those particular scheduled areas. Now here clearly we can see the regulations can restrict the transfer of tribal land to non-tribal members. So the question clearly asks us if the transfer of tribal land to private parties for mining can be declared null and void under which schedule? It is the schedule number 5. Let us discuss the next question. This question is from 2022. If a particular area is brought under the 5th schedule of the Constitution of India, which of the following statements best reflects the consequence of it? So the question is asking us the best possible answer. Statement A. This would prevent the transfer of land of tribal people to non-tribal people. Statement B. This would create a local self-governing body in that area. Statement C. This would convert that area into union. Statement D. The state having such areas would be declared as a special category state. The questions about 5th schedule are a repeated theme. And this particular question is asking about what is the implication of making and declaring a particular area as a 5th schedule area. So what will happen here? The president will through a notification will declare some area as a scheduled area, and that particular area will get special provisions and special protections. And one of the main protections that they have is because it is a tribal area here, there will be restrictions on the transfer of land from the tribal people to the non-tribal people. So this statement is correct. And this 5th schedule doesn't create any self-governing body as such. There is the tribal advisory committee, which is an advisory body, but there is no self-governing body as such. Hence this statement will be incorrect. Statement 3 says this would convert the area into the union. No, this wouldn't convert the area into a union territory or something. This is also incorrect. The states having such areas would be declared as special category state. No, those states will not be declared as special category state. So hence this is also incorrect. The correct answer is option A. Now let us look at the in-depth explanation. The 5th schedule has certain provisions for the administration and also about the control of certain scheduled areas and how to protect the tribes which are there in that scheduled areas. And the exception being the 4 states of Assam, Meghalaya, Tripura and Mizoram, because the provisions for these 4 states, they are contained in the next schedule, that is the 6th schedule. So scheduled areas are those areas where the president through a notification will declare after consulting the governor of the respective state, and the governor has to submit a report to the president about the administration of such areas. The report submission will be normally annually, or whenever the president requires the governor to submit a report, the governor will submit a report. The governors also have power to make regulations for the peace and good governance of those particular scheduled areas after consulting the tribal advisory council. This tribal advisory council, like the name itself suggests, it is advisories are advisory in nature. The advices given by the tribal advisory council or the TAC, they are not binding in nature. So this TAC is also advisory consulting body. It is not a self-governing body. And various regulations and protections given to the scheduled areas are they might prohibit or restrict the transfer of land to a non-tribal, or they might regulate the allotment of the land to tribal members, or they might regulate the money lending that happens in these scheduled areas. So if we consider all these factors, option A best reflects the consequence of including a particular area as 5th scheduled area. So A is the correct answer. Let us discuss the next question. This question is from 2023. With reference to the scheduled areas in India, consider the following statements. Statement 1. Within a state, the notification of an area as scheduled area takes place through an order of the president. Statement 2. The largest administrative unit forming the scheduled area is the district, and the lowest is the cluster of villages in the block. Statement 3. The chief ministers of concerned states are required to submit an annual report to the Union Home Ministry on the administration of the scheduled areas in the states. How many of the above statements are correct? So how would you solve this question in the exam? This question is talking about scheduled areas. Here you should recall that scheduled areas are discussed in the schedule number 5 of the Constitution. So if you recall there, it is actually the president who through a notification will declare a particular area as scheduled area. So read statement number 1 again. Within the state, the notification of an area as scheduled area takes place through the order of the president. So that is correct. The largest administrative unit forming the scheduled area is the district, and the lowest is the cluster of villages in the block. The administrative areas, when particular areas is declared as scheduled areas, in that it will be the district, and below the districts we have the block, and below the blocks we have the cluster of villages. So this is also correct. The chief ministers of the concerned states are required to submit an annual report. Here is a twist. It is not the chief ministers who have to submit a report, but it is the governor who will submit the report. Hence, this statement will be incorrect. How many of the above statements are correct? 1 and 2 are correct, 3 is incorrect. So only 2 statements are correct. Answer will be B. Now let us look at the in-depth explanation. This particular statement, the question, it is talking about the Schedule 5, and Schedule 5 talks about certain areas where the president will designate certain areas through an order as the scheduled areas, and this will be done only after the consultation with the governor of the respective state. The president has the power to make changes in the areas, in the boundaries, and also rescind or designate particular areas as scheduled areas. So that is mentioned in statement number 1. And statement number 2 is also correct because, like I already explained, the largest administrative unit is the district. Below the districts we have the blocks, and below the blocks we have the cluster of villages. And finally, it's the governor who will submit a report to the president regarding the administration of such areas. And the report submission can be annually. Generally, it is annually by the governor, or whenever the president wants the governor to submit a report, the governor will submit a report. Finally, after considering this report, the center will give directions to particular states regarding the management of those areas. So it's not the chief ministers, but it is the governor who will submit the report. Hence only 2 statements are correct. Let us discuss next question. This question is from 2024. Consider the following statements. Statement 1. It is the governor of the state who recognizes and declares any community of that state as a scheduled tribe. Statement 2. A community declared as ST in a state need not be so in another state. Which of the following statements are correct? Now, how could you solve this question in exam? If you recall, it's not the governor of the state who has the power to declare a particular tribe as a scheduled tribe in the state, but the president of India has this power. So because of that, this statement is incorrect. It's not the governor who has the power, but it's the president who has the power. Statement 2 says, a community declared as scheduled tribe in a state need not be so in another state. Yes, whenever the president declares some community as a scheduled tribe in a particular state, it is with respect to that particular state only. The same community may or may not be declared as ST in some other state. So this statement is correct. Now, which of the following statements are correct? Only 2 is correct. Let us look at the in-depth explanation now. Article 342 and clause 1 says the president, see clearly it is mentioned the president, it's not the governor, but it's the president. The president may, with respect to any state or union territory, and where it is a state, after consulting the governor of that particular state through a public notification, the president will specify that particular tribes or communities, they are scheduled tribes in relation to that particular state or UT. So what this statement says, the president through a public notification If it is a UT, the president will directly issue the public notification. If it is a state, after consulting the governor of that state, then the president will issue the public notification, and in that the president will specify that a particular tribe or a community will be considered as scheduled tribe for that particular state. And Article 342 clause 2 says only the parliament has power to add or remove any tribe or community from the list of scheduled tribes which are specified by the president notification. And once the list is issued, they cannot be changed by another notification by the president, because now only the parliament has the power. The Indian government follows certain criteria when declaring a particular tribe as scheduled tribes, and it can be based on the primitiveness, the geographical location, the shyness, the social and educational criteria, the economic backwardness. All of these criteria will be considered, and once all of this criteria is considered, then the list is made, and this list is specific to that particular state or union territory. And a community which is declared as scheduled tribe in a particular state, it need not be so in another state. It means that a particular community can be a scheduled tribe in one state. In another state, it may not be considered as a scheduled tribe. So this list is state or union territory specific. So this same line is mentioned even in the question. A community declared as a scheduled tribe in a state need not be so in another state. Coming back to the question, it's not the governor, but it's the president who has the power to declare. But when it is a state, the president will consult the governor of that particular state. And again, even after the consultation, ultimately the president only issues the notification. And statement 2 is correct. So hence the answer will be B for this question.